Am I far enough away from people so I don't have to wear my mask? Okay, all right. Good morning, everyone. We'll call the hearing on the Committee on Commerce, Consumer Protection, and Health, along with the Committee on Technology, to order. It's nice to have Chair Keoho Kaloli with us this morning. I try not to butcher his last name.
That was great. Thank you. Nice to be back.
So on our joint agenda, we have one item. It's House Bill 2572, House Draft 2, relating to privacy. The purpose of this measure is to modernize the personal information for purposes of trying to minimize security breaches and prohibit the sale of geolocational information without consent. That is the proposed SD1. So we have a number of testifiers. I would just say for the record that because all of this is only going out online, we don't have any live testifiers with us. It's all been written. So it limits our ability to ask any questions during the hearing. But in the unlikely event that we have to abruptly stop this hearing due to some technical difficulties, if the internet goes down or something else, lightning strikes the building, the committee will reconvene to discuss any outstanding business at 10 o'clock on Wednesday, June 24 in conference room 229. And if we have to convene then, we will publish, we will post a notice on the legislature's website to advise anybody who may be interested in the remaining items that we have. So let's start, members, with the item that is on our joint agenda. This is House Bill 2572, House Draft 2. As I said, it proposes to modernize information. We have testimony in support of this matter from the Office of Consumer Protection at DCCA. Their testimony is online. Don't believe that they have, basically they're telling us that the proposed SD1 corrects some existing statutory inadequacies by expanding the definition of personal information. Apparently our statutory framework was 14 years ago. And so it definitely does need to be updated. The Department of Commerce and Consumer Affairs says that the regulation of geolocation data set forth in Part 3 will advance consumer privacy by prohibiting the sale of consumer location data without their consent. We also have testimony in support from the Department of the prosecuting attorney, and unfortunate, oh, there it is. They discuss various segments of the bill and offer some, noting that some of the language in here came from the task force. I think they're asking to put back sections 4 and 5 into the SD1, so we can take that under advisement when we take a look at the measure more closely. Let's see. All right. I'm getting such a small image here that the chair is having a hard time reading it. Okay. The next testimony we have is from the CTIA, which is a consumer information technology company, and they have some concerns about this measure and testify in opposition that the definitions are overly broad and the legislation would have a host of unintended consequences. The CTIA is the trade association for the wireless communication industry. We also have testimony in opposition from Charter Communications, basically saying that they acknowledge the changes to the bill since its introduction and support some of the goals behind it. They oppose the enactment of the bill in its current form unless certain clarifications are made to address several unintended consequences. The next individual or group that sent testimony in opposition is the State Privacy and Security Coalition. They are a coalition of 30 leading telecom, technology, retail, payment card, online security, and automobile companies, as well as 8 trade associations, oppose the substitution amendments for House Bill 2572. So those substitution amendments are actually the proposed SD1 that is on our agenda. And they go on to discuss some of their concerns: overbroad definition of sale, lack of service provider provisions, overbroad definition of precise location, and the other unintended anti-privacy consequences. And note that this is not the right time to impose costs on Hawaii business. The next organization that submitted testimony in opposition is a trade association that says they are the leading advertising and marketing trade association, collectively representing thousands of companies across the country, including many businesses in Hawaii, ranging from small businesses to household brand advertising agency and technology providers. Their membership includes more than 2,500 companies and are responsible for more than 85% of the United States advertising spend that drives more than 80% of the digital advertising spend. They support the legislature's intent, but oppose it in its current form. We have testimony offering comments from the Hawaii Bankers Association, from the Hawaii Public Policy Advocates, from an organization called Reflex, a world-leading provider of technology solutions that supports government, insurance, and financial services. They request an amendment that they say is urgently needed related to the use of geolocation information to prevent unintended consequences of this measure. They want that the Section 4 not apply to any activity involving the collection, maintenance, disclosure, sale, communication, or use of geolocation information to detect security incidents, protect against malicious deception, fraud, or illegal activity, or to prosecute those responsible for that activity. That seems intent on perhaps gutting that measure. And lastly, we have a comment from Lynn Matasau, in full support of the measure, noting that our individual privacy should not be compromised and we should have the option to accept or to refuse. let's see, we also got some late testimony from the Office of Enterprise Technology Services. ETS supports the proposed SD1, which redefines personal information for the purposes of security breach and prohibits the sale of geolocational information and internet browser information without consent. Mr. Murdoch, Doug Murdoch, who's the CIO of the Office of Enterprise Technology, says that they support updating the definition of personal information in HRS 487N that includes expanded identifiers and data elements which are consistent with prevailing practices for current security breach notification laws. We also have testimony in opposition from the Retail Merchants of Hawaii, saying that they believe this type of legislation is premature as there are a lot of concerns being raised that should be addressed before the measure should pass. We also have late testimony from Hawaiian Electric. They offer comments and suggest amendments to the proposed SD1. Talking about some of the intended consequences that could arise and a manner in which to delete it or to fix it rather. They also request that in the proposed SD1, Part 2, Section 2 be amended by deleting subparagraph 7 regarding healthcare and adding the word financial to subparagraph 5. In other words, requiring a password to allow access to an individual's financial account. And the final late testimony that the joint committees received is from the Hawaii Credit Union League. These folks, the Hawaii Credit Union League is a local trade association for 51 Hawaii credit unions representing over 800,000 credit union members across the state. And they are in opposition to this measure. They understand and agree with the intent of the bill, but suggest a number of amendments for clarification. So they are concerned with the bill in its current form. Did we get any additional information? Members, any comments that you would like to put on the record? I would note for the members here and everyone listening that it is not the committee's intent to make a decision on this matter today. We intend to defer decision-making to Wednesday, June 24th at 10 o'clock in conference room 229. This allows the chairs and the committee members to continue to look at the measure and come up with some perhaps suggested amendments, or at least allows us to confer on a proposed recommendation for the joint committees. Okay. Apparently, do we have a late testimony from Kelly McCanley's? I don't have it on my list, but
Just read it.
Senator does, so.
Yeah, I just want to acknowledge in the online testimony packet, the supportive testimony of Kelly McCanley's, who, submitted testimony in support.
Okay, any others that we may have missed, Chair? Okay, any comments from committee members? Okay, I believe that brings us to the close of our public hearing. And as I indicated, the joint committees will defer decision-making to Wednesday, the 24th at 10 o'clock in conference room 229. We are adjourned. Ready? Good morning. We'll call the Committee on Commerce, Consumer Protection, and Health to order. We have two items on our 10:15 agenda. Apologies, we're running just a tad late, but we had a good discussion in our previous joint hearing with TEC. So the first item on our agenda this morning for CPH alone is House Bill 2425, House Draft 1. This is relating to domestic abuse. It amends the definition of domestic abuse under Hawaii's insurance laws and laws relating to domestic abuse protective orders to include coercive control between family or household members, defines coercive control, and it has a effective date of 7/1/2050. I would note that this measure has a referral to CPH, JDC/WHAM. So if we move this measure, we will be moving it out to another Senate committee for a set of Senate committees for their consideration. We have a number of testimonies in support from the Hawaii State Coalition Against Domestic Violence. They note that one of the benefits of this measure is that it provides another legal protection for victims on the prosecutorial level at sentencing. And the Department of the Prosecuting Attorney, City and County of Honolulu, refers to the definition of domestic abuse when determining sentencing pursuant to HRS 586-11. So they support it for those reasons and others. And I will note for the record that the testimony is posted on the legislature's website, so you're able to see all of the testimony that has been submitted to the committee. The next testimony is from the Domestic Violence Action Center, and this testimony is also in support. They note that it's important for us to name the behaviors and hold abusers accountable for their perpetration of abuse, even if it doesn't leave a visible bruise. So they look forward to favorable action by the legislature on this measure. The next testimony we received is also in support. This is from Parents and Children Together. They also ask us to take the SD1 proposed, which amends the definition of domestic abuse under Hawaii's insurance laws. And they talk about the importance of updating those measures. Also, testimony and support was submitted by the Hawaii Psychological Association. Testimony in support from Joshua Gerbert, who is a board-certified foot and ankle surgeon who practiced for a number of years in San Francisco before retiring to the Big Island, and in his practice saw women who were coercively abused and discovered that there were no laws to protect them. So he thinks this measure is long overdue. We have testimony in support from Barbara Ota. She is also current president of the Hawaii Acupuncture Association and a longtime advocate in her professional and private life. She lives on Hawai'i Island, and she says that it's important that we pass this measure to protect all members of our families. She says coercive control and all its definitions clarify abuse and will provide means for our citizens to live in a viable, safe environment in the state of Hawaii. We have testimony in support from Benton Keali'i Pang, PhD. We have testimony in support from Deborah Thompson, from Nancy Creedman. She notes that as COVID-19 and the stay-at-home directive has been in place. It's impacted victims and survivors, and there are new tactics of coercive control that have been employed by abusers. And we do know that the calls to the crisis line and visits to our women's shelters have indicated that domestic violence seems to be increasing in these times. We also have testimony and support from Eileen McGrath, from Jeannie Ota, from Bob Deal, says that every household in Hawaii deserves to be free of coercive control. Deborah Deal also submitted individual testimony making the same recommendation that we move this measure forward. And we also have testimony from Anita Miseli from Hawai'i Island, and asks that we take this opportunity to begin to address this extremely important human rights issue regarding women feeling safe to speak out about coercive abuse without feeling shamed. Do we have late testimony? Oh yes, here we do. I see. We have testimony also in support from Sean Benton. He's a current member of the board of directors of the Domestic Violence Action Center and strongly supports this measure. And we also have testimony in support from Amy Chung. Any other testimony? Members, any comments that you'd like to make on this measure before we move to the next one? We will be doing decision-making on this measure at 10 o'clock, 10:15 tomorrow, 10:15, because we'll have the joint decision-making first.
Sure, just thank you. I just wanted to thank all the people who put in the testimony and the supportive work. I think this is really an essential change. I was really happy to see all the support for that.
Yes, we did get a nice, and particularly when everybody's dealing with so many other issues and we're having to do things remotely, it was nice to see people taking time and sharing their mana'o with the committee. Our next measure is House Bill 2317, House Draft 2. This is a governor's package measure. The referral is CPH, JDC, and it relates to security. This is the Uniform Securities Act, Vulnerable Elder Financial Exploitation, and protects elders and vulnerable adults from financial exploitation in relation to securities. So we have testimony in support from DCCA. Every time I change, it reverts back to its very small self. We have written testimony from Tai Nohara, who is the Commissioner of Securities, Department of Commerce and Consumer Affairs, and they strongly support this measure. They note that the proposed SD1 represents consensus language between the DCCA, the Security Industry Association of Hawaii, the Securities Industry and Financial Markets Association, the Executive Office on Aging, the Department of Human Services, Adult Protective and Community Services Branch, and the National Association of Insurance Agents and Financial Advisors of Hawaii. Basically, what this bill will do is require a qualified person to report to the Commissioner of Securities upon a reasonable belief of suspected financial exploitation, and authorizes the qualified person to notify an individual reasonably associated with elder, the vulnerable adult, or the account, or a third party previously designated by the vulnerable adult of the suspected financial exploitation, and then allows remedies to pursue from that. We have testimony in support from the Director of the Department of Human Services. They request 2 amendments. They agree with the proposed SD1, but for clarity and consistency, they recommend in section 1 that we add the words elder or the to the proposed section. So it would be convert money, assets, or property of the elder or the vulnerable adult to deprive the elder or the vulnerable adult of the ownership, use, et cetera, et cetera. So I think that's consistency, and the chair is certainly open to adding that for clarity. Their second amendment is to strike the words "the persons" in section, on page 3, section 4, 346-222 Hawaii's revised statutes. So it would read carry out or arrange for essential activities of daily living, and strike out the persons. So I think we can take those, Chair will, with the committee's permission, take those as clarifying amendments. The next testimony is from the Office of Information Practices. They have a technical amendment. Let's see. OIP notes that the provision in the bill that makes specified records not government records as defined in the Uniform Information Practices Act. OIP does not object to providing confidentiality for financial records. However, this position, as it's worded, would make records of not even that are not even government records, such as an agency, would not be required to deny a request in writing based on UIPA. So we may need to take a look at how we might do that. They have suggested that if we want to make those kinds of records clearly exempt from disclosure in response to any type of UIPA request without making them an exception to UIPA's normal scheme for how agencies must respond to records requests from the public. OIP would recommend that the sentence in the bill, page 7, line 16 to 17, read, all records made available under this section shall be exempt from disclosure under Chapter 92F. So members, that would be something the chair would appreciate your mana'o on when we get to that aspect. We have testimony in support from the Hawaii Securities Industry Association. They also note that they support and are in agreement with the revised language in HB 2317 HD2 proposed SD1 as proposed by the Commissioner of Securities of the Department of Commerce and Consumer Affairs. We have testimony in support from the Security Industry and Financial Markets Association, which is a trade association representing over 350 large, medium, and small broker-dealers, investment banks, asset managers, many of whom have a strong presence in Hawaii. They note that Americans lose approximately $2.9 billion in cases of financial exploitation. And apparently seniors are among the most vulnerable. And since some of us in this room would identify as seniors by virtue of age, it would seem that none of us would want to be part of that financial exploitation. This agency testifies that SB 2317 HD2H Draft 1, Senate Draft 1 is a fair and balanced tool that will help curb both the economic and psychological damage associated with financial exploitation. And they appreciate our willingness to hear this measure to assist vulnerable adults in our community. We also have testimony in support from Eileen Garies. Any other testimony? Members, any comments on this measure? If not, shall we go forward then to House Bill 2202? And this is relating to cemeteries. This is a measure that we have heard in this committee in previous years, and apparently for some there is still a problem. We have testimony in support of this measure from DCCA, and this is from Charlene Tamanahu with the department, who is the licensing administrator for the department's professional vocational licensing division. The purpose of this measure, she notes, and it's worth advising those in our listening audience, is to clarify that churches granted an exemption under HRS section 441-22.1 are exempt from all requirements of HRS chapter 441. Other exempted entities shall comply with any provision of 441 upon order of the department's director. And an entity such as a church exempt under federal tax law is considered a church for purposes of the exemption. She notes that Act 14, Session Laws of Hawaii in 68 authorized the then cemetery board to exempt any cemetery authority from the bonding and fee requirements for license renewal reinstatement that did not actually engage in pre-need sales, have a licensed cemetery salesperson, or sell for financial profit. Since 1968, exempt cemetery authorities have not been regulated and have been treated as exempt from HRS 441 requirements. In codifying the current practice, the Department Cemetery and Funeral Trust programs, this bill will help the program become more efficient in overseeing cemeteries and provide clarity for exempt entities regarding the requirements of HRS Chapter 441. In addition, churches and other nonprofit exempt cemetery authorities will continue to be responsible for maintaining and caring for their cemeteries. That's the opinion of the DCCA, which does oversee some of these. We have testimony in opposition from the Hawaii Funeral and Cemetery Association. They are opposed because they believe that in the event a church or nonprofit is actively selling cemetery interment rights to any individual for below or above ground burial, or for cremation below ground or above ground interment in a columbarium, and providing a guarantee of perpetual care maintenance, the church or nonprofit should be required to maintain a perpetual care fund, and that fund should be audited. So they are not keen on the measure before us. They do support the opportunity to provide cemetery memorialization to their members, but feel that there needs to be regulation protecting the consumer. HFCA would support an amendment to the proposed SD1 of House Bill 2202, House Draft 1, that would require a church or nonprofit to maintain a perpetual care fund under Hawaii revised statutes. If they do offer pre-need purchases on monthly installments, they should be regulated under the trusting requirements. We have testimony in support from the Episcopal Diocese of Hawaii. Says that the passage of this bill would be a blessing to the members of the Episcopal Church and the hundreds of local families who wish to rest in their spiritual home that has brought them much joy, peace, and strength throughout their lives. So they urge us to pass this. Hasoi Garden Mortuary Inc. Takes a different view and is opposed to the SD1. It was noted by the Hawaii Funeral and Cemetery Association. We have testimony in support from Resurrection of the Lord Catholic Church. similar to the previous testimony we heard. We also have testimony and support from the Roman Catholic Church in the state of Hawaii, Diocese of Honolulu. We have testimony in opposition from Mililani Memorial Park and Mortuary. They believe that if churches are going to be doing this, then they need to be under the same rules that mortuaries are. Same sentiment from Nu'uana Memorial Park, testimony in opposition. From Borthwick Mortuary, testimony in opposition. We have testimony and support from a number of individuals. Gar Pereira Balmores, Marvin Choi, Richard McNally, David Coleman, Lisa Sakamoto, Laurie LaGrange, Alan Urasaki, Diane Lamosao, Father Greg Honorio, Michael Maguai, Jane Raga Mandoy, Celeste Oda, Karazan Tubana, Deborah Bisson Melton, Eileen Payton, Father Ephraim A. Tomas, Father Khan S. Wong, Father Robert Stark, James Severinson, Marlene DaCosta, Marvin Uehara, Melinda Lacaille, Patrick Downs, Paul DeVille, Paulette Adams, Peter Pereira, Priscilla Timbreza Molina, Remedios Castro Jamayo, Reverend Anthony Pagan, Reverend Monsignor Terrence Watanabe, Reverend Herman Gomes, Richard P. McNally, Sharon Chavez, Sister William Marie Elenicki, Stephen A. Kula, Walter T.Y. Lau, Keith Cabellas, Eva Andrade, Alicia Nakamoto, Leslie Noguchi, Reverend Monsignor Gary Secker, Bernice Walker, Vincent Benet. Anybody else here wishing to offer a testimony? And we have some late testimony. Let's see, all of this appears to be in support. So we have late testimony in support from Rita Maria Sacred Heart Church in Hawaii, from Mark Clark, parishioner at St. John Vianney Church in Kailua, from Ivan Louis Kwan in support of the measure, and also T. Michael Hogan Jr., former chairman of the Board of Trustees, St. Louis School, in support of this measure. Any other testimony? Members, any comments? It's difficult if we have issues or questions not to have anybody to ask them of. But since we will be deferring decision-making on this measure until Wednesday at 10 o'clock in conference room 229, we can continue to look at these, and if there are questions, we can submit them to the department for their manao.
So thanks, Chair. I guess while I see that some of the services that people are wanting to be able to offer may not require the full regulatory structure as a mortuary or a large area, I think the point of having some type of perpetual oversight or fund to support things, because this will be long term,
yes,
is valid. So maybe if we can talk to the department about something that would meet that would be helpful.
Okay.
Thank you.
I will reach out to the department and see if they can assist us with any language. Any other comments or questions you would like the chair to follow up? Okay. Members, I believe this brings us to the end of our agenda. Madam Clerk, is that correct? Okay. So we will adjourn the hearing, and we will reconvene June 24th at 10 o'clock in conference room 229 for decision making. We're adjourned.